Next chapter, prospectus and allotment of securities. Just imagine you need some money. Okay. Either you're going to do business or you may be planning to go for an outing. Okay. Anything it can be. For whatever it is, we need money, right? You agree? So yeah, just plan for a outing with your friends or outing with your family. Need not be doing business alone. Okay. What is the source of money here? What is the source of money for you? Don't take it too personal. Okay. Just tell me in a random manner what you do. Yeah, you can join. You ask your parents. Okay. If you're not the sole income producer, then you ask your parents. If you're working or something like that, you may be taking out from your own income. Okay, we have. But here, when we talk about company, the company being an artificial person, it cannot make money on its own. For the very first step, you need to have capital to start its business. And it's given by whom? Yes, you can please join with me. It's given by whom? Shareholders or subscribers? Okay. Actually, when we talk about the subscribers concept, they are the person who start the company, and when they give the declaration, signing in the subscription clause, they say that the company is not yet started. They say that we'll take at least one shares. Okay. Obviously, only when the shares are allotted, they'll be called as shareholders. Okay. Only when the shares are allotted, they'll be called as shareholders. Okay. In general, we can call as investors or shareholders or subscribers or anything like that. Okay. Or in the case of company not having share capital, contributories. Okay. So, being an artificial person, it has taken the very first capital from the MOA. You agree with me? Actually, MOA we have only one clause. What clause we have related to share capital? The share capital clause. Okay. But when we talk about the sixth clause, the subscription clause, it is giving an idea about how many shares are being taken by how many persons. Minimum 2 persons for a private company and minimum 7 persons for a public company. So how many are taking how many shares is mentioned over there. And soon after a company is incorporated, they need to bring the capital inside. This is how the company brings up very first capital inside. Then after, probably the company starts its business with this capital, and doing its business, it earns some income. Okay, the turnover, what we call it as turnover, and with the help of this turnover, the business is run. Now, what happens is the business needs money. Okay, what is going to do? Either it's expanding its business global wise, or it's expanding its business with respect to economies of scale, making large production. Any some way or the other, it is in need of money, or probably there is a demand in the future, but to get ready for compensating the demand, to bringing the equal demand, what we are doing here is now we are employing the employees, we are buying the raw materials and everything we need, and we need to expand our business. Okay, so what we are going to do here? That's why company is going to take the money from outsiders. But what law says is this prospectus is a concept that is not applicable for private company. Why? Why it's not applicable for private company? Yes, by definition, private company is prohibited to issue the prospectus not only for shares, for debentures, for securities, everything in general, securities in general, for deposits, debentures, shares, and all. So it's not going to applicable for private company. For public company, it can get the money from outsiders, but it cannot compel a person to take money. Okay. Instead, what it can do is it can say that we are going to offer shares. Okay. We are going to offer means actually it's inviting that we are going to offer the shares. If you are interested, you can buy the shares. Okay. If you are interested, you can buy the shares. For example, please try to recall this invitation to an offer concept. You remember you have done this concept in Indian Contract Act. You remember? Invitation to an offer. Once again. We relate with Contract Act and we relate with Companies Act. Okay. Contract Act. Example, let me go for, in a contract act example, display of goods in a shop. Okay, display of goods in a shop. In Companies Act, this is related to prospectus. Let me finish it contract act angle first. You just imagine that you're going to a shop. Okay, so this is a shop, you're visiting a shop. It's a supermarket, like everything is arranged in a beautiful manner, and you get tempted and you go for buying. Okay, what you do? You just push a trolley, you put everything in the trolley, and go to the counter for paying the bill. And that salesperson over there scans the product, and you pay the money, and he delivers the product. So what is happening here is display of goods. Okay, what you are doing? You are going to buy the goods, take it to the counter, which means you are offering. So what the shopkeeper is doing, the supermarket wala or the shopkeeper is doing, he is inviting you to offer. This is what he calls as invitation to an offer. He is inviting you to offer. Okay, he's inviting you to offer. You are offering by taking the trolley to the counter. Okay, then you pay the money. He says that he accepts the money. That's what he calls as acceptance. The same thing is happening in Companies Act also. This concept is directly related with invitation to an offer and offer. Instead of invitation to an offer, we'll not use the term here so, but instead we use the term called as prospectus. Okay, this prospectus is not only for shares. It is in general called for securities, shares, debentures, deposits, everything put together. Seeing the prospectus, you as an investor interested in buying the shares, you fill the application form and you deposit the application money saying that you're going to buy this number of shares, which means you are actually offering. You are the offerer over there. Okay. To whom you are offering? To the company. Okay. So company may be accepting, probably might have learned this concept in the company of course, oversubscription, undersubscription. Yeah, the same concept I'm trying to describe. So the company will be accepting. This is what you call as acceptance. Probably if in the prospectus it's 1,500 shares, please try to imagine that 1,500 shares is going to issue. And if the application received are exactly 1,500, it's mean exactly subscribed, the company will issue. In case the subscribed are only, that is applied for only 1,400, yes, it will fully issue. In case, this is what you call as under subscription, right? In case 1,600 or 1,501, what it will do? It will go for proportionate or whatever it is. So this is what you call as oversubscription. Okay, the company doesn't have the right to go for this one. Why? Because in the prospectus, how much it is inviting? To issue only 1,500 shares. But before seeing this prospectus, the number of shares to be issued, also the company will check whether it is there authorized in the Memorandum of Association share capital clause. You remember the share capital clause? The line, or you can just refer the material. The share capital, yes, you can please refer. The share capital, yeah, please join with me. The share capital of the company is some 10 lakh rupees, something like that, 10 lakh rupees divided into some, okay, I have taken 10 lakh, okay, 1 lakh, 1 lakh number of shares, each of rupees 10. Okay, so this will be the lines in your memorandum of association, rupees 10. Just imagine if the company has already issued 1 lakh number of shares. Then is it possible for the company to issue this 1,500 shares, which I have taken in my example? No, it's not possible. Because this is what you call as the authorized capital. Above this, the company cannot execute for further. It becomes limitation of action for the company. In case, just imagine the company has issued, depending on this, the company has issued just 50,000 number of shares. So now it's going planning for 1,500 shares. Yes, you can do so. Okay. So first thing, it should be in prospectus. Not only in prospectus, before that, probably you should not just think, okay, it's there in the prospectus, you can execute. No, it's not that way. You have to check whether there is in prospectus. Before that, whether they are eligible to do so. Memorandum of association. Before that, it is whether eligible to do as per the act. These two things basically comes for every company. You have to check with that and you have to check with the memorandum of association. Then you have to go for checking with what is there in the prospectus. And most of our prospectus, when you go for, we have something called as golden rules of prospectus. It mentions what are the things you have to put in the prospectus, what are the things you have to do, and other things. And all. Probably I'm planning to buy a machinery. Okay, so you have to mention for what purpose you are going to issue this 1,500 shares. So you're planning to buy a machinery. Okay, actually, the machinery cost some 2 crores. Okay, but you're planning to issue the shares worth 2.5 crores. What did you say? Do you think that, okay, we mentioned in the prospectus, nobody is going to worry? Okay. அவங்கெல்லாம் அவ்வளோலாம் பார்க்க மாட்டாங்க. They'll just directly issue it. You're going to see in such a way? No, you cannot do so. Once we see the prospectus, we may be tempted to buy the shares in the company. Also, we have to check each and every line with the purpose and everything and all. We may not be so much legally involved regarding the procedures, how the prospectus may be issued, but we have to take care of how the prospectus is defined for this amount. Okay, probably how I'm going to confirm this mission worth only 2 crore and why the company needs 2.5 crore. I need to confirm. Whom do you go and refer? And this mission has been imported from Europe. So you're going to call an Europe technician or engineer and you're going to check with them. Now, most of the technology we borrow from German technology, Japanese technology, European technology. Okay, we are not following, nowadays we are following Indian technology, but still. Okay, so the mission is going to be imported from Europe. How are you going to check with that person, with that company, or we cannot say, right? And this prospectus is going for the public, and each and everybody cannot check that. So, what the company is doing or has to do is it has to get an expert statement to say that yes, this mission's worth is 2 crore rupees. Then again, there is a question: why you need 0.5 crore extra? Probably this mission is 2 crore rupees. We are going to have this mission not for the lifelong. It's a depreciable asset. We are going to hold it for some 5 years. And how much it will take for that 5 years? The repair and maintenance and other things and all. So how much is going to value for that? So that's why we need addition to 0.5 crores. So all these may be involved. So if it is 2.5 crores, they need to show the breakup for 2 crores and 0.5 crores. Okay. So this is about prospectus. What is prospectus? We have to link this concept with invitation to offer, and acceptance. We will not call here as acceptance. Instead, what we call here? Allotment of securities. Allotment of securities. Is it okay? And we will not call it as an offer or offerer. Offerer is the public who are interested in investing. So we will not call it as offer. Instead, we call it as application. Is it okay? So we'll come across prospectus. Okay. Application, share application, and along with that, we'll go for allotment of securities. Is it okay, Pa? So from the single material, the detailing provisions of this content is the chapter name itself is chapter 3, prospectus and allotment of securities. Actually, it's divided into 2 parts. Chapter 3 is divided into 2 parts. One part deals with public offers. See, it's not going to be applicable for a private company. It's going to be applicable only for public companies. So usually in general, we call it as public offer. But what happens is public offer means there will be thousands and thousands or lakhs and lakhs of subscribers may be interested in investing in my company. So what I do here is I am in need of emergency money, which means it has to be, or I'm expecting the money to come inside the business in a very short period. Okay. So what I'm planning is instead of bringing this prospectus to all the person, prospectus nothing but invitation to an offer, right? Instead of giving this prospectus, what I'm planning is I'm going to offer directly. Please try to understand, I'm going to offer directly to a certain number of persons, maximum 50. Maximum 50 persons, not more than 50. Okay. And this is what is called as private placement. I am stressing this word private placement is not for private company. This private placement is for the public company only, but for limited number of persons. So this is only for the maximum 50 persons. Okay, so this is covered under part 2. So there are 2 parts. Part 1 covering from 23 to 41. Part 2 covering only one section, section 42. Is it okay? Before continuing, let us go with Barrett. So what is chapter 1? We have done the chapter 1, right? What is chapter 1? Preliminary. Contains 2 sections. First is usually. First is short title, extent, commencement and application. Next is definition. Then chapter 2, incorporation of company and matters incidental thereto related to MOA, AOA, alteration of MOA, alteration of AO. So starts from 3, goes on up to 22. Okay. Then we'll go for, now today's session is on chapter 3. The heading itself is prospectus and allotment of securities. Part 1 is dealing with public offer. From which section to which section, Pa? 23 to 41. Okay, then part 2 related to private placement. This is covering only 42. Can you please go through the headings, Anu? Yes, please. Can you please go through? So if you check this part 1, you'll find that 23 will be telling what do you mean by public offer and private placement. Actually, it's not going to define exactly, but because of the procedural aspect change, we'll be defining this as public offer and this is not public offer, which means this is a private placement. And when it happens to be a listed company, what happens? So, which means what is the power of the SEBI? So, how it's regulating issue and transfer of securities? That is dealt under Section 24. And Section 25 says that there'll be a document containing offer of security for sale to be deemed prospectus. What does this deemed means? Actually, we're not following all the procedures, but law says it's a prospectus. Okay. Again, if you go and link Indian Contract Act, there should be one person to offer. There should be one any CA inter students without studies Contract Act here. You haven't studied Contract Act so far? No. Okay. So please try to link. When you go for entering into a contract, there should be one person to offer, there should be one person to accept. Only the offer is accepted by the respective person, it will be called as a contract. But there is something called as quasi contract where even though you need not offer and accept, the law says it's a contract. That's why it's a quasi contract. The same way, there is something related to 25. It's also a type of document, but there is prospectus. But it's not mentioned as prospectus anywhere. It is mentioned as some document containing offer of securities. But law says it's a deemed prospectus. Law says it's a deemed prospectus. Okay. What are the matters to be specified in the prospectus, like expert statement, declaration by the directors, etc.? In case, after issuing the prospectus, if you are varying any terms of contract or object in the prospectus, what are the things you have to follow? Okay. Then, offer of sale of shares by certain members of the company, only like promoters or something like that, they are going to opt it. That's about 28. 29 is public offer of securities to be dematized form. It is not compulsory that all the companies, means public companies should have in demat form only, dematerialized form only. And how we are going to give the detailings of the prospectus? It's called as advertisement of prospectus. Okay, that's why we call this as invitation to an offer. You can please make a note of it. Section 30 says it's nothing but advertisements itself means it's an invitation to an offer. Okay. Then the other categories are other prospectus are one is shelf prospectus, another is red herring prospectus. Apart from that, how we are going to issue the application forms for securities in 33? Yes, 34 and 35 talks about the liability. One liability is criminal liability, one liability is civil liability. Criminal liability is also for misstatements in prospectus. Civil liability is also for misstatements in prospectus. Can you guess what would be there in civil liability and what would be there in criminal liability? Criminal liability means punishment, which means monetary fine or imprisonment. If you go for civil liability, damages and compensation. Okay, so that's about civil liability. So we have to discuss both. Then punishment for fraudulently inducing persons to invest money. I'm inducing you to invest money. I should not do so. And it's a fraudulent inducement. You should not do so. Okay. So offer is something that you have to come from the concern, from your concern. Okay. You should not be compelled to buy it. So doing fraud means we are not giving the complete statement. We are not giving the genuine statement. We are something hiding from you. That's a fraud. Okay. If it happens, what could be the action by the affected persons? Sometimes 38 says that punishment for personation of acquisition of security, which means I'm using other person's name. Okay. See, from 34. 34 is criminal liability. 35 is civil liability. 36 is punishment for fraudulent. 37 is what is the action can be performed. 38 is punishment for personation of securities. Till here is about prospectus. The last 5 section is about penalties. Okay. Liabilities. 39 is dealing with allotment of securities. And if it is a listed company, the securities will be dealt in the stock exchanges. And we need to know something about the GDRs. You remember GDRs we have discussed already regarding the custodian bank, regarding the depository bank, and they'll be buying the shares and they'll be giving in the custody of the. So I remember I just drew this map. This is an Indian company. Okay, this is a custodian bank. Okay, there'll be a foreign investor who will be investing the money. Okay, but the shares will not be directly given to the foreign investor. Instead, the company will give in the custody of the custodian bank, which is an Indian bank, and this bank will have a agreement with this depository bank, and this depository bank, on getting the confirmation that the Indian bank has given the custody of the shares, this bank will go for issuing the receipts. This is called as deposit receipts, and this in general called as global depositories. These concepts are covered in section 41. Okay. After this, all should be done in shortcut because we are in need of urgency of money. We need it immediately. So we go for 40. Is it okay? So I'm now following from single material. Yes, you can please join. So prospectus, applicable section is covering from part 1, not all the sections, but 23 to 38 alone. It is there till 41, but we are covering till 38. This is with respect to prospectus from chapter 3. So I started with this from the Indian Contract Act. There we say invitation to an offer. Here we say prospectus. There we say offer. Here we say applying for that. And there we say acceptance. Here we say allotment. Okay, fine. Then prospectus for shares. Also, it can be prospectus for debentures also. Probably you can have a slash and you can write it. It can be for deposits also. Or you can just put everything in brackets and you can say it's for securities in general. Okay. Nature, very, very important part. Actually, if you understand all these bullet points, what I have listed down here, you'll understand what is a prospectus in general. It's nothing but an information booklet. See, I'm going to buy product of your company. Okay, so what I usually check the lifespan of the product, how far it will be helpful for me. So everything will be checked. Probably I'm going to buy a 10 rupees product, but I'll check everything. Probably you're going to buy a pen, 2 rupees. What do you do? Okay, it's a habit for many. You get the scribbling pad and you just go for scribbling in. Okay, we usually do it. The same thing happens. We are going to buy the shares and spend the hard-earned money. I'm going to invest in the company. So I need to get all the information. So what the prospectus in general called, or in short called as information booklet. And they're asking you to offer, that's why it's called as offer document. Actually, prospectus is not the offer document. Prospectus is inviting you to offer. But for each and every prospectus to be, there should be an enclosure or application form. So it will contain an offer document. Probably you can change it over here. Contain an offer document. Contains an offer document. Okay. Any document as prospectus inviting offers to the public. What's there, ma'am? See, this word is important. I want you to highlight. Any document, it need not be stated or need not be given the heading as prospectus. It can be any document, okay. But what is there? It is inviting for the public to offer for the securities, which means now this document becomes a prospectus. So the document need not have the heading document. The document need not have the heading as advertisements or something, but the content says that it is inviting the public to offer, means it becomes prospectus. It's very, very important. It's like a notice, it's like a circular. When we go for prospectus, it's a wider concept where we cover red herring prospectus, where we cover shelf prospectus. Probably when we go inside, we'll check on this. Advertisement, section 30 clearly says advertisement published in any manner. Say, I want to link these 2 points. What the third point says? Any document. What this point says? Advertisement in any manner, in any media, in any format, anything. You just come across with any wordings or something saying that it's inviting the public to offer, it becomes a advertisement, or any document, it becomes a what prospectus. It is dealt in section 30. Also, when that advertisement is clearly stated as prospectus, it should specify the contents of the MOA. Which content? Obviously, almost MOA means all the content, but here we'll discuss it object mostly. Okay, right? And the object, liability, amount of share capital, everything has to be discussed, and the signatories, name and share subscribed, and the capital structure. So almost all the clauses. Is it okay? Shall I take over? Types of securities. So we are starting from section 23. Issue of securities for a public and for a private. Provision applicable is section 23, subsection 1 and section 23, subsection 2. In which modes it can issue the security. This is not about prospectus. This is about issue of securities, like a general section. It's about issue of securities. In which mode it can go for? subscribing. Okay, that is issuing the shares. See, it's a public company. It can go for issuing prospectus. Prospectus is meant for initial public offer or fellow public offer or follow-up public offer. Or it can be for offer for sale of securities also. What do you mean by offer for sale of securities? We have discussed that you're saying that it's nothing but deemed prospectus. What is that offer for sale of securities? No idea, right? Okay. Or we might have studied, probably I'll go for this concept later, okay, when I come there. Second, it can go for private placement. Third, right issue and bonus shares. But whereas if you go for private, see only the first point will not be present. See, right issue is there. Okay. Bonus shares is there. Private placement is there. Okay. Actually, this A, B, C is the order given in the paragraphs, so that's why I couldn't change. So we have to go in this order. If you're following the section numbers and paragraphs, you have to exactly write the same one. A, B, C. Here, A is prospectus, B is private placement, C is right issue, put together bonus shares. Whereas if you go over here, right issue and bonus shares first, then private placement as listed B. Okay. What are the things you have to state in the prospectus? Go for section 26. 26.1 says that please join every prospectus issued in the formation or subsequently shall be first dated. Not only that, second signed. Not only that, it's a information booklet. So it should contain the information. What are the informations needed? Financial information. The director's report, that report, this report, okay, corporate governance report, compliance report, okay, all the reports will be there. The reports as per needed will be specified by the SEBI if it happens to be a listed company. Proviso specify such as SEBI specifies. Okay, so this is one. And if you go for C point, there will be a declaration saying that compliance of the provisions are complied with and nothing is contrary happening and other reports also. When we go for 5, please highlight this often asked question, expert statement. Okay, who is an expert? If I am talking about a mission, buying of a mission, who is an expert over there? The engineer, the mechanical team. Okay, that expert will be giving a written content to issue in the prospectus. Who's that expert? That concerned aspect. Probably if you are going for buying some equipments for medical treatment, then who will be the expert over there? Along with the doctor's technicians. Okay, so those experts, what they'll do is they'll give a written concern saying that all the matters stated in the prospectus are true. Okay, and also to include, please highlight this one. The expert statement not only giving the written consent to include this in the prospectus, not only that, they will also include is not been withdrawn before delivery of copy to the registrar. Once a prospectus is being ready, is not directly issued to the public. Before that, a copy will be delivered to the registrar, and after that only they'll go for proceeding with giving to the public. Okay, so here this line will be included. What this line says, not withdrawn before delivery of copy to the registrar. Which means what? I gave a statement, so and so. I gave a concern. And I'm also saying that I have not withdrawn this document, this statement. In case what happens, probably I'll just fix a date. Uh, first, first of February. This expert statement has given, and he has given a written notice that it can be published in the prospectus. And the prospectus is submitted to the register on 10th February. And along with this, a written statement, not withdrawn, etc., is also included. This statement is also included. Okay. 10th February, they are going to give this to the registrar. It's not given. But what happens is, 9th February, this expert sends a letter saying that I'm going to withdraw my consent. Which means 10th February is not the date to give to the registrar. Okay, once it is being submitted to the registrar, it's very clear that the expert has not withdrawn. Which means it's very clear that he has included the statement along with that to the company. Is it okay? This is very, very important part. Eligibility, who can be that expert? Expert is not only with respect to technical qualification. Expert should not be a person engaged or interested in the formation, promotion, or management of the company. He should not be anywhere dependent on the company or company is dependent on the expert. Okay. I'm talking about this doctor, okay, who is an MD and he's very much having knowledge about this technical aspect also. So he is giving the expert statement. Okay. Now what happens is he's the director of the company. That hospital. No, he cannot give. Because the expert who should not be that expert. The expert should not be a person engaged or interested In where? Formation or promotion? Not only that, management of the company also. Should not be a promoter, should not be a subscriber, should not be an investor, but should not be a management, which means what KMP or independent director or director. Okay. All this should be considered. Okay, let me continue. Others, probably other details need to be included in the prospectus is minimum subscription, how much minimum has to be subscribed to the public, minimum application value. We know that 5%, usually we say 5%, right? Act also says 5%, but in case we feel like we give it for 10% as application money, 50% as application money, we can give it. Okay. Board of directors should clearly mention why they are going to utilize this money and other related provision has to be mentioned. Okay. Actually, when we go for section 26, see, we are here. Matters to be stated in the prospectus. Here is subsection 1, 2, 3, 4, 5. 5 is about the expert statement. So we did with subsection 1 and subsection 5. Okay, can you just refer this table? We did with subsection 1 and subsection. See, here's subsection 1, subsection 5. Okay. Then we go for subsection 2 now. Whom these things are not applicable. See, I'm issuing this to the existing members. They are already members to my company. They very well know about my business. So we're just going for expansion and we are expecting our existing members to buy the shares. So what we do? We go for simple way of subscribing, issuing the shares. Not only for existing members, existing debenture holders, or when you go for right shares. What do you mean by right shares, now? The right for the shareholders to get the shares when the company is issuing this type of a share for the right share. Only the members of the company can go for buying the shares, right shares. Okay. And uniform shares as previously issued in all respects. Please highlight. First one you can logically link. Please highlight the second one. Uniform shares as previously issued in all respects. Probably earlier you have issued the shares. That's rupees 10 rupees. Okay. Okay. It's a normal ordinary shares. And the same type of share you're issuing now also with no changes. Then it's nothing but it's a uniform shares. Where the voting, see, we have two types of equity shares. One is normal equity shares and that is ordinary equity shares, and another one is with differential rights. Okay, I'm not going to go for differential rights. I'm going to go for uniform shares, which means in all the already issue of the shares, I have done the same thing. This time also I'm going to do the same. So in that case, all these are not needed. So this is subsection 2. Subsection 3, applicability of subsection 2 probably subject to this. It is for formation of the company or subsequently also. Please highlight. The first time you're going to issue the shares to the company, formation of the company, not only for during the formation, but also what? Subsequently, you can follow the same. The company has been formed some 50 years ago, and now you're going to issue the shares. Probably the first time when you issue the shares, it was just X, Y, and Z. Now, there is no X. Okay, H people gone away. Okay, no X, no Y, no Z. But there are some other new people planning to buy the shares in my company A, B, and C. The same provisions are applicable. Okay, which means subsection 1, whether it's applicable or not, depends on subsection 2, and not only for formation, but also for the subsequently going for issue of shares. Okay, this is subsection 3. Now we'll go for subsection 4. Before directly delivering to the public, we have to deliver a copy to the registrar, and that prospectus should be signed by the director, or if it is with respect to the formation of a company, proposed director or authorized authority. With respect to subsection 6, please highlight is very, very, very important. Okay. On the face of every prospectus, you have to state a copy is delivered to the registrar as per the subsection. This is 4, sorry, please correct it. Because 4 only says that we have to deliver it. Okay. Each and every prospectus. See, one copy is enough to submit to the registrar. Okay. But you are planning to give this share application money to 1 lakh number of public. Normally it goes through the bank only. We have this system called as intermediaries, merchant bankers and lead merchant bankers. So you are planning for some 1 lakh number of prospectus, which means prospectus means it includes the application form also. In this 1 lakh number of prospectus, there should be a statement saying that a copy is delivered to the registrar as per this section, the earlier section, subsection 4 of 26. Okay. And not only that, it should clearly specify what are the attached or included documents. Expert statement, that one, compliance report, etc., all this. What are the inclusions? It has to be listed. And earlier we had the subsection 7, now it is omitted. It says that consent of all the persons named in the prospectus is required. Actually, it says once you give the declaration, you sign the declaration, it's understood they have given the consent. Okay, so for expert, it is very clearly stated. For others, it's not required. Not required means enough. Okay, subsection 8, validity of the prospectus is important. Not valid if it issued more than 90 days after the date on which the copy is delivered to the registrar. So if this is the date, it's delivered to the registrar. Okay. Within 90 days, it should be registered and it should be delivered to the public within 90 days. How the line starts? Not valid. Then, if issued more than 90 days, which means valid if issued within 90 days. So, exactly 90 days or on the 98th day. Is it okay? Why they so? Why they say so? 90 days is approximately 3 months, which means approximately 1 quarter. For many big companies, especially when you go for public companies and listed companies, definitely 1 quarter change means there's a big change in the financial state. And what are the things you're including in the prospectus? The financial information also. So if 1 quarter changes, the financial information changes. The financial information changes. Definitely, your decision to whether invest in company shares or not changes. Okay, so that's about 8. 9. If you're not following all these, then pay penalty. Company has to pay penalty 50,000 to 3 lakh. For other persons who are involved in this, expert or other, whatever it is, they have to pay a penalty of 50,000 to 3 lakhs. Okay, so this is about subsection 9. And there is something called as golden rules of prospectus, where you have to include only true statements and no false statement has to be included. When we say no false statement, it says that false statements should not be included. And not only that, untrue statement also should not be included. What do you mean by untrue? See that here is a company which was paying regular dividend. Okay, regular dividend. When you go for sources of dividend, it says that it has to pay from the current profit. Okay, dividend is nothing but appropriation of profit. How do you say dividend? How do you define a dividend in simple terms? It's nothing but appropriation of profit. Okay. So what is the source of dividend is? Either you pay from current year profit. Okay. Or you pay from previous year profit. Okay. Previous year profit means previous year profit will be pooled in resource and surplus. Okay. Else, sometimes the government itself gives some support you, like subsidy, like, okay, where you can pay from that. Else, you can pay out of the resource. Okay. Probably, reserve means, again, if you ask me, we have the surplus separately. Under reserves, we have free reserves. Okay, there's a difference between reserves, free reserves, and the surplus. Okay, so here, this company is paying dividend regularly, but it's not paying out of profit. That's the current year profit. It's paying out of the reserves. So when it's paying out of the reserve, it's not stated. The whole thing is not stated. It's not giving a false statement. It's giving a right statement, but it's not fully stating it correctly. So we say that no true untrue statement has to be there. That's what about the golden rules of prospectus. Is it okay? So we are covering section, we have covered section 26 part. Again, can you please go through to here? See, whenever we talk about this contravening provisions, right? We talk about this provisions penalty. If you are not following section 26, this penalty will be attracted. Apart from the 34 and 35, criminal and civil liability will be attracted for mistake. Okay, so this will be attracted. Criminal liability will be attracted. So everything. Okay, so you have to get ready for paying all the monies. Okay. We'll go for section 27. Variation in terms of contract or objects in the prospectus. We have issued the prospectus. Now we are planning to change some terms or the objects. The main content of the prospectus means. What subsection 1 says here is it should not vary. But our intention is not to make the mistake and change. Our intention is to make a genuine change. Okay. In that sense, you can get the approval by passing a special resolution, which means what? We are not saying it's a ban or it's prohibited completely. You can do it, but you have to go what? Except with the approval by passing a special resolution, you can do it. Which means what? You have to conduct a EGM or AGM. Mostly AGM will not be applicable because AGM is something which will come after 6 months of the financial year. So if it's an emergency need, you have to go for passing of the resolution in EGM. You have to call for extraordinary general meeting. Proviso provided. What do you mean by provided? It's condition. It should be published in the newspaper. First provision. Second provision. Further, not to utilize a raised amount for buying, trading, or dealing in equity shares of any other listed company. See, I am a company started this business and raised the capital to do my business. Okay, I should not take the money from your hand and I should not invest in another company. That's not my business. Okay, if there are some companies, see, there are some companies, for example, mutual funds, asset management company. The company itself is brought or formed only to invest in another company. So that company is fine. But generally, when you're borrowing, going for buying or getting the money from the public and issuing for the what investing in the other companies, it should not be done. You should not utilize the raised amount for buying or trading or dealing in equity shares of any other listed company. Is it okay? Which means you should not go for investment. Okay, but you can go for investment as subsidiary company. Please try to highlight. Buying, trading, and dealing is not related with investing in subsidiary. It's what we interpret here. This is the banana we are interpreting. And if you're not interested, probably with this object change or variation in the terms, subsection says that there should be an exit offer provided by the promoters or the other controlling shareholders who's dissented, which means what? Who's not agreeing. Dissenting means not agreeing. Affected or not agreeing. Not agreeing or affected shareholders with exit price. And the exit price we have to follow from SEBI's position. Okay, this is with respect to variation. So probably you may get this as a direct heading. What are the provisions covered in variation, etc. So you have to go for these two subsections. Shall I take over? Now we'll go for types of classification of prospectus. First one, offer for sale. In short, we call it as OFS. Two sections will be covering here. So applicable provision is 25 and 28. Before continuing, we have to remember this. See, so far what we were discussing till this concept, before covering this concept, we were saying that the company wants to issue the shares to the public. Okay, this is what we call as prospectus. Now what we are going to discuss here is, there is a what member or a shareholder X, Y, Z, A, B, C. Likewise, how many? Some 1,000 shareholders are there. Okay, they're all put together shareholders. Okay, they're all put together. They want to sell the shares. See, all the shares are wholly dematerialized form. You can directly go to the secondary market, either to BSE or NSE, and sell it. But what these shareholders they decide is, we go through the company and we sell to the public. Please try to understand. We go through the company to sell to the public. Which means instead of directly selling to the public, they think that we'll all put together the number of shares and we ask the company management, who's the company management board of directors, we tell them and they will sell on behalf of the existing members. Okay. What's the background work or why they do this? See, they are selling the shares directly to the public. There may be a rival company and those company will be buying my shares and directly be in the hands of the rivals. So they want to protect my those shareholders. They want to protect my company. So they ask me, okay, and on behalf of them, I sell. I, in the sense, the board of directors sell. This is what you call as offer for sale. See, how can I say this is prospectus? Prospectus is inviting you to offer, but this is something directly offering. Who is offering? Company here becomes the agent for the shares probably held by the members XYZ ABC. Probably, for example, let me go this way. X is holding some 1,000 shares. Okay. But he might be interested in only 500 shares. Yes, they can do it. Okay. So likewise, A may be holding some 200 shares. So all put together, they are planning for this 1,000 shares. So this is one reason. Another one reason is company may be planning for, as we started with an example, 1,500 shares. Okay. But company has this, forecasting the demand. Company has this in its mind, saying that probably 1,700 shares may be subscribed. It's actually oversubscription where law doesn't allow this. What the company do here is, If anybody, the existing shareholders are interested to give this 200 shares, they are added in the prospectus, which means 1,500 will go to the public through the prospectus as invitation to an offer, whereas this 200 will be going to the public directly from the existing shareholders through the company. Here, company will be completely acting as the agent for the existing shareholders who are going for offer for sale. See the term itself, offer for sale. Directly they go for sale. So very beautiful concept. Let me take you through. Follow from section 28. Okay, subsection 1 says members. You clearly know whom do you call as members. Is there? They are already shareholders. They hold shares, and the names are taken to the record in the register of members. So, like members, existing shareholders. Who are the members? Existing shareholders. What's the difference? You're all here, right? Members need not be a shareholder. Okay, shareholder need not be a member. What's the difference? I have discussed all this concept already. Members need not be shareholders. See, whom do we call a shareholder? In short, who hold the shares. Whom do we call as members? Register of members group, they hold the name. Okay. There is a person A who sells the shares to B. Case 1. Holds 1,000 shares. Completely sells to B. Okay. Now tell me, who's a shareholder? Who is a member? B becomes a shareholder if in the records the name is not changed, which means A has to be removed and B has to be included. If not changed means A is the member as per the records. Okay, now I go for second case. A transfers only 500 shares to B. Now A is a shareholder, B is a shareholder, and if there is a change in the record, then he is a member, he is a member. If there is no change in the record, he is only the member, he is not the member. See, there is a lot of difference. Here we are mentioning, or this subsection 1 mentions, we are talking about the members. Not only members means what? The name is there in the record. Not only that, they have to have the shares. So not only members, they are also has to be the shareholders of the company. They are selling to the public through prospectus. They do it not on their own, but through the company. Through the company means in consultation of the board of directors. Either the whole shares will be sold or only part of the shares will be sold. Okay. Subsection 2 says it's nothing but a deemed prospectus. Okay. So what are the provisions you are following with respect to the prospectus? As per section 26, you follow everything. In case if you are not following, it goes with respect to misstatements or omission, where you're going to go for section 34 and 35, criminal and civil act, everything applies over here. So all the things apply over here because we say it's a deep prospectus. Okay. Subsection 3, only thing is there should be a collective authorization which should be given by the shareholders who propose to offer to the public, to the company. And all the actions will be taken. Not only that, please highlight the company has to be reimbursed, which means all the expenses they pay that has to be reimbursed to the company. So it's not the company going to deal with the money, right? Okay. XYZ, they are planning to sell the shares through the company to the public. Okay. There may be A, B, and C. Why they need to bear the cost? If company is bearing the cost, it's whose money? The shareholders' money. Why the company has to bear the cost? Okay, so that's why the company can reimburse all the expenses incurred because of the sale from the shareholders. Is it okay? So this is with respect to 28. Now we'll go for 25. Document containing offer of securities for sale to be deemed prospectus. The same similar to the concept what we have discussed earlier. What is offer for securities is held for right shares. Right shares. Offer for sale. Okay, offer for sale is for existing members to the public through the company. Offer of securities is meant for right shares. Please highlight somewhere. It's also considered as deemed prospectus. Okay. Continuing. Subsection 2. Make offer for sale within 6 months to the public when they can make. After allotment or agree to allot. Please highlight. That's why we say members. See, if the shares are allotted, you become the shareholder. Okay. But the shares are not allotted. They have agreed that the shares will be allotted, which means you're not getting in hand, but you'll get it. So in that case also it will be called as a shareholder, but you do not get the shares. In that case also you can go for offer for sale. The whole consideration to be received by the company in respect of the company has not been received at the date of when the offer is made. Please highlight this one also. The consideration, who has to receive the consideration? See, they have allotted means okay. They have not yet allotted. Definitely the company is going to allot to X. Okay. See, now read the second line. I'm just defining with an illustration. The company has agreed to allot to X. Is not allotted, agreed to allot X. Which means what? X is in a position to pay the allotment money. Not paid. See, first is after allotment, which means allotment money is paid. Second is agreed to allot but not allotted, which means allotment money may not be paid by the X person. So here the whole consideration to be received by the company. Who has to receive it? Company will receive it. In respect of the company has not been received at the date when the offer is made. Which offer is made? Offer for sale is made. At this particular date, X has not paid the consideration, but company has agreed to allot. It's a promise. Company has agreed to allot. Yes, it can go for offer for sale. It's allowed. Logically இல்லையே மேம். Law says it's allowed, so allowed. Okay, ரொம்பலாம் யோசிக்காதீங்க. Okay. But, think wisely. Okay. Legally. Law says it's allowed, it's allowed. Okay, don't take it a different way. Some additional information like net amount of consideration. Probably you need to understand, right? How can I believe that the board of directors saying that X, Y, Z, A, B, and C, all they have got for offer for sale? How I believe them? See, the company is going to buy a machine. At least we have the expert statement you can relate. And now the company is not in need of money. The existing shareholders are selling the shares to the public. So how can I relate? Yes, there is a contract with the company saying that we can do it, and there is an allotment of the said securities also there. Yes, we can relate, and we can inspect this contract. And the person making the offer and named in the prospectus as directors of the company. Is it okay? We'll go for subsection 4. Signing the documents. Yes, please highlight. If it is a company, who has to sign? Two directors. If it is a firm, half of the partners have to sign. The respective person. Okay, half of the persons. Miscellaneous, the minimum subscription, minimum application money, board of directors for what purpose they are utilizing, everything will be similar. So this is 25 and 28 done. Okay. Shall I take over with 29? Shall I take over? 29 is public offer of securities to be in dematerialized form. So we have to issue in demat form only. Earlier it was like soft copy and hard copy form. Now it is only for private company. It is in hard copy form, like share certificate. Hard copy means share certificate we have. For all the public companies should be issued in demat form only. What do you mean by demat form? Dematerialized form. Earlier, like non-dematerialized form. Non-dematerialized means the shares, how I know that the shares in my name. So share certificate will be given. Okay, the share certificate will be given. X, Y, Z, A, B, C. So all hold the shares of a company. Okay. Now X wants to sell the shares. See, when we go for the features of the company, the important feature for this form of a business is free transferability of shares. So X wants to sell the shares to any person like L, M, or any person. What happens here is X will sell the shares to L. Then X has to give a document to the company saying that I have sold the shares. Then company will check all the provisions are right. Then company will issue the share certificate to L. Is a lengthy process. Okay. Company's business is to do business, not this business. This you need to understand. Okay, why the company is formed? We'll all do the business. We'll make a profit. Okay, we'll divide the profit. We'll expand the business. This is the business of the company. But just imagine there is one X or one Y or one Z is okay. Thousands of X will be there. Thousands of Subulashmi, thousands of Meena, thousands of Kupukami. Gone. So there'll be a special person allocated only for this reason. And we don't know which Kupusami is alive and which Kupusami is dead. Okay, this is all there. So what happens is government sees all these things and we want to go in the technological world contemporary to all the things, and so we introduce this one called as demat shares, which is in dematerialized form. So the spelling is this, dematerialized form. This is what you call as demat shares, which means you need not give us share certificate. You need not give us currency note. Either you give it as GPay or Paytm. So it's directly credited to your account. You need not have separate currencies in your hand. You need not have separate share certificates in your hand to directly transfer over there. So in case here, now X wants to transfer to L, X will say it's not directly happening through X and Y L account. It's happening through a broker, share broker. Okay, so he's taking care of, and X will say the instructions, sell this shares for this amount, and this share broker will be crediting to this L. Okay, so there will be another broker for L. He will be selling that, buy the shares for probably, let me go for some 150 rupees is the share value. Okay, this is for ABC company. L wants to buy for 150 rupees. X wants to sell for 150 rupees. We don't know who is X, who is L. Okay, X doesn't know who is L. L doesn't know who is X. Share broker has the account. All this is done through the shareholder. All this is through the share broker. All this is done through another share broker. All this is being controlled by two persons. Whom do you call us? Any idea? CDSL and NS. Okay. CDSL means Central Depository Services Limited. NSDL means National Securities Depositories Limited. So only we have two companies in India who are completely taking care of this. Okay. There will be different intermediaries between here. We call them depositories and depository agents over here. Okay, we'll not exactly call them as share brokers, we'll call this depository agents who are working for this NSDL and CDSL. Okay, right? So now we'll go for register of members. So this is company ABC Limited register of members. It will be only two names. One is NSDL, one is CDSL. Access, if these two names are there, which means what? This company has entered into an agreement with this company and this company. Okay. If the register of members name, register of members book consists only these two names, and this separately will be maintaining a register of book for records containing all those persons' name, and also a CDSL will be containing the records of all the persons' name. This person holding this much of shares in this company, and this record is completely sufficient, and this called as deemed register of members. So if you go and refer this register of members book, it will be almost like an empty page. It will be almost like an empty page. Okay. If you go and refer the NSDL and CDSL record, you go for thousands and thousands of pages. One will be holding one shares. One will be holding lakhs and lakhs of shares. Okay. You tell me, one share is how much percentage? One person is holding lakhs and lakhs of shares. Probably he is holding like 2% of the shares. 2%, but number of shares in lakhs. I am holding only one share. Namno invest பண்ணுவோமே அப்படின்ட்டு. I am holding only one share. You just imagine how many zeros I have to put after the decimal and before one. Okay, it will go like this. But what the law says is, even though you hold one shares, we are not considering with respect to percentage. You are the shareholder of the company. You are the member of the company. So if the company is holding an AGM, you are invited. Okay, if the company is giving dividends, you are given. If the company is going for selection of managing director or whatever it is, your resolution is needed. So everything will be considered. So at least buy shares in all one companies. Check and see how much will be treated. Okay. You buy a share in Reliance company, Ambani's company. Okay. The treatment given to Ambani will be given to you also, no? Really, I'm saying. Because law says you're the shareholder, you're the shareholder. Okay. You're also shareholding shares, he's also holding shares. So you're Ambani, okay. You're given the notice to attend the AGM. Okay. The only difference is he himself gives the notice. That's different. Because it's Ambani's company. Okay. The notice is sent from the company to Ambani family, to Ambani's address. The notice is sent from the company to you. Yes, you're also treated equally. Ambani is also treated equally. Okay. But he's holding like 55% or 75% shares. I'm holding only one share. No issues. Let me have coffee, tea, finish it and come. Okay. Right. Okay. So that's our dematerialized form. So what they're doing is they are holding it soft copy form. That's all. Okay. So they have to issue in demat form. Companies and other classes of companies, you need not go here. You go for Depositories Act. You need not refer Companies Act. Okay. And mandatory for such classes of unlisted companies to be held in demat shares also. So if it is listed and public means it's mandated. Unlisted company is so probably go for the regulations and check. Okay. Other companies may, which means what? We convert to demat form and we follow the same. Okay. So section 29. Section 30. Advertisement of prospectus. Already I have discussed this. You have to specify the contents of the memorandum of association. So you're giving this as an advertisement. Advertisement is nothing but invitation to an offer. So you're giving this as an advertisement. So you have to specify those contents of memorandum of association. What are the clauses? You need not give the name clause. See, you need not go and just take the copy of the memorandum and attach it. It's not doing that way. Okay, so you have to give the object clause, okay, which means objects of the company. They are asking you to specify the contents of the MOA only. They are not asking you to specify MOA, which means what? Object clause has to be given in detail, liability has to be given in detail, capital structure, and signatory names and share subscribed and capital structure. Is it okay? Then, shall I go for shelf prospectus? Or you can go to here, please. Shelf prospectus. See, the company wants to raise capital, okay, and it's planning to raise around some 25 crore rupees. Okay. But there's an immediate need of money where 50 crores is sufficient. But another 10 crores, if it buys, that is, if it gets subscribed, which means a total of 25 crores, it will be utilizing 15 crores. What about the 10 crores? It cannot go directly and invest in another company. So there are some rules where it says you can go for unencumbered securities, the government securities only. Okay. So if you're a director or if you belong to the management of the company, will you think this is a wise decision to go for subscribing this 10 crore also? No, definitely it's not. Because once the company comes inside the business, the directors are responsible for giving the reasons why this money is not utilized. So the company may be planning that for this immediate 6 months, to once we start the project or something like that, for this immediate 6 months, 15 crore is sufficient. After 3 months, we need some 7 crores or we need some 3 crores. After another 3 months, we need the remaining 7 crores. So this 25 crores can be split as 3 or 4 categories. See, I just gave this example as 15 crores. Probably I may be in need of 5 crores first, then some 5 crores. I may take it as this denomination also. So what happens is instead of taking 15 crores directly, that is 25 crores directly, I go for 15, I go for 3, and I go for 7. Obviously, this is also raising money from the public. This is also raising money from the public. This is also raising money from the public, which means we need three prospectus. Section 31 says these prospectus is not needed. If you are doing all this within 1 year period of time, one prospectus is enough, and the remaining can be done using the additional information document called as info memorandum. This is what you call a shelf prospectus. And law says you give the first prospectus giving all the details, including the second and third details also. And when you go for issuing for this 3 lakhs worth or 3 crore worth and 7 crore worth, you give the additional details. For the past 3 months or 4 months, what are the things or what are the changes happened in your company? Any charges created? Any contingencies reported? You state all those things only, and it's contained in the document called as not prospectus, but it's called as information memorandum. Law says this is called as a deemed prospectus, and this prospectus is not generally called as prospectus; it's called as shelf prospectus. Okay. This is in the point of favor of the company. Now we go for the point of favor of the investors. What's the investor will say? Will think. See, probably you're trying to invest or buy shares in this company. Currently, you don't have money. And you get this self prospectus saying this company is planning to raise money from the public. Some after 3 months or 4 months, 3 crores and 7 crores. Now you'll have an idea. Okay, anyway, I'm going to get this 3 crores after some 5 months. Okay, I plan for the investing in this company. So you can plan wisely, and the company is also planning as per the law. So this is what you call as shelf prospectus. Okay, so shelf prospectus follows from section 31. Let me go for the colloquial definition. A prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without, please highlight this word, without the issue of further prospectus. Instead of further prospectus, what issue there? Information memorandum. Is it okay? Subsection 1 says it should be filed at the shell prospectus should be filed at first stage of the offer. This one or more issues we are mentioning the certain period of time, right? Mostly the certain period of time should be maximum 1 year only. Okay. And the date from which this 1 year is calculated is from the opening of the first offer. Please highlight. It's not from the date of submission to the register. It's not from the date of circulating to the public. It's from the date of opening of the first offer. Okay. For multiple offers is valid. It's not like, see, they say one or more issues only. You can take 10 issues also, but usually will not take 10 issues. See, 10 issues means average one issue per month, right? It's not a magazine. Okay. So usually we will not do that. If it is 3 or 4 issues, then it's fine. See, usually what we do is we take it for 1 quarter. For financial side, we are professionals, we deal mostly for 1 quarter. Or you have to go at least more than 60 days because that is a lot of procedural aspects they have to follow. We have to allow the shares, we have to bring the money inside the company. It's not a small job. Okay. So for multiple offers to the public, no further prospectus is required for second or subsequent offer. Only one prospectus is sufficient. So is that sufficient? No, it's not sufficient. Subsection 2 says file an information memorandum. It is to be given in a particular format. The format is called as PAS2. Okay. PAS2 and shall contain what are the main details it has to contain? The material details. Okay, material significant details. New charges. See, this is the first prospectus you filed. And this is the date you are filing this information memorandum. What are the changes got here in this period? Only that is sufficient. Because what are the things happened before that is all applicable here. It's all available in this document, right? The main shell prospectus. What are the things applied here? Probably new charges, some financial changes or other later changes. And we have to file this 1 month prior to the second and subsequent issues. 1 month prior. So definitely there will be a gap of 1 month. So it's not possible to go for 10-month issue and all. Maximum they'll go for 4 or 5, not more than. Okay. And that also happens when it goes for lump sum of money. Okay. So let me carry on. Proviso. Application with advance, yes, can be received before making of such changes. And you have to intimate if anybody desires to withdraw, they can withdraw and it have to refund within 15 days. So you are planning that you will buy some 20,000 shares now and later period for the second issue, you go for buying some 10,000 shares. Because you don't have money, you have the application money and you have invested in the application money. And in case in information memorandum, they have brought some changes and now you are in the mindset not to invest in that company further. See, it's your money only, no? You can decide. But you have given the application money. So the company is given or the company can intimate the changes and if desired to withdraw, yes, they can refund the money with 15 days because only the share application money is taken, the allotment is not done. Only if the allotment is done, acceptance comes. See, follow from Indian contract. What do you mean by allotment of share? Acceptance is done. You have to pay the money. You have paid the application money. It's only the offer taken place. Only when it's accepted, it becomes a contract. Okay, you have to be very clear. Then subsection 3, yes, is a normal section. It's called as a deemed prospectus. But information memorandum alone does not have any validity. Along with shelf prospectus only, it has the validity. Okay. Shall I go for a red herring prospectus? Section 32. Red herring prospectus is something is not including particular details like price of the shares, how many shares is going to issue, quantum and quantity they say. Okay, quantum or quantity. Quantum of shares or quantity of shares. How many shares they are going to issue? They are not stated. Okay. See, as I was telling, I'm going to issue 1,500 shares and each share is 10 rupees. Okay. I don't know how much my company's worth share will be. Either 10 rupees or I don't know. See, 10 rupees is a face value. Face value is different. I'm talking about setting it premium. I don't know how much the public will be subscribing my shares. And I don't know how much shares to be issued. So I don't know about the price. I don't know how much shares to be issued. Quantum or quantity is not known. If these two details are not known, means the company is not giving the full particulars to the public. But other things, expert statements, for what purpose you are utilizing money, everything is given. Only these two is not present, means we cannot, long since you are not going to invalidate the prospectus, long since we call this as rendering prospectus. Actually, we use this statement. You can please write this phrase. A prospectus, rendering prospectus is understood by this phrase. A prospectus prior to the prospectus. It will contain all the details of the prospectus. except the two things, price and quantum. It's called as how the letter in prospectus is called as prospectus prior to the prospectus. Giving see prospectus means it should contain all the lines, right? Golden rules to prospectus will be followed. But letter in prospectus not contain these two details. So you call this as a prospectus only because law says it's a prospectus prior to the prospectus, prior to the main prospectus. Okay. Okay. See here, subsection 1, prospectus. So no price, quantum, and some key details may not be there. Subsection 2, yes, please highlight file at least 3 days prior to the opening of the subscription list and the offer. Okay. Subsection 3, same obligations as prospectus. Whatever it is, everything will be followed as it is. And upon closing, yes, please highlight the subsection 4 is directly linked with subsection 1. Upon closing, file with registrar and SEBI all the details like closing price, what are the details to be not included earlier but now included. All the details has to be given. How much capital you're trying to raise, that's the quantum of the closing prices. Okay. Section 33, I produced a prospectus. I'm a very big company, okay, like Reliance or Tata. Everybody knows what my business is. So I need not give a 200 or 300 page prospectus. What I do is I give the salient details, that materialistic significant details. What is the need for the raise of this capital, etc., probably in 1 page or half a page or 1.5 page, along with an application form. This is what you call as IBS. What are the important details you have to mention? That will be mentioned. Okay. So only the salient features of the prospectus will be given. Subsection 1, application form should accompany the abused prospectus. Is not the only intention to reduce the number of pages, is to reduce the content, which is only necessity that will be given. Okay. So we should not reduce the application form. We have to give the application form. So it's clearly mentioned. Subsection 1, give the application form along with the IRS prospectus. Okay. Provision is not applicable for underwriters or securities not offered to public. Who will call as underwriters? We have come to this concept. It's somewhat a different concept, may not be necessary, but I'll just give an idea. It's a beautiful concept, but company in a plan to issue the shares, 1% of shares will be given to the public, certain percentage of shares. Certain percentage of the shares also will be given to the public, but not directly to the public, to the brokers. This will be done to the bankers. Okay, this will be done through brokers. Brokers are there. See, when you use the term brokers, immediately something will flash in your mind. Okay, commission தான் work பண்றாங்க, right? Maybe I may be colloquial, but this is the thing happening. Brokers means they work for the commission. Okay, then there are another one person. They also issue the public, but they are called as underwriters. Brokers are also agent. Underwriters are also agent. They also work for commission. They also work for commission. I say I'm not going to deal this concept at all because it's directly going to the public. Then they give the application form, etc. So I'm not dealing with this concept. So this public is receiving to brokers. This public is also receiving to the brokers, but they're not called as brokers. They are called as underwriters. The brokers, when they issue the shares for the company to the public, they'll raise a percentage as commission. This one also raises a percentage as commission, but only difference is, for example, let me give some figures. 1,000 shares are being planned to give through brokers. Here also 1,000 shares are being planned to give through underwriters. If this public is opting only 800 shares, okay, the remaining 200 shares not subscribed. Here, this public is planning to, this public has planned to go for 700 shares. The remaining 300 shares, it will be taken by the underwriters themselves. See, underwriting is a term used for a kind of agent where in case probably if you go for selling, credit sales and all. So when we talk about this credit sales, we have to talk about this PBD. Okay, provision for bad and doubtful debts. Okay. So whenever we plan for this 3 months credit sale and we are not expecting the money to be returned this 3 months, what we do? We go for planning for adjusting. But if this sales is done by a underwriter, then there is no provision for bad and doubtfuls to be created because law says the underwriters will pay. Okay, the underwriters will pay. The 700 shares, we subscribe with the public. The 300 shares, not subscribe with the public, but it's meant for underwriter. Means the underwriters will be taking this balance 300 shares. Okay, which means the company can sleep peacefully at night. The company need not worry because the company, whenever is planning for subscribing or this minimum subscription, this one we don't know how many public will be taking. This one, how many shares will be taken by the public. So we cannot rely on the brokers. What the brokers, how much percentage will be given for the brokers for this 800 shares only. But for underwriters, definitely, if this 1,000 shares is given to the underwriters, no worries. Under business growth. So what happens is this percentage will not be same as the broker's commission percentage. Will be given extra. So whenever we say underwriters, they are like agent, but they are not like normal agents. So for this 700 shares, the public will become the shareholder. For the remaining 300 shares, the underwriters will become the shareholder. Is it okay? Want to make a note of anything? Shall I take over? And security is not offered to the public. So probably the private investment, private place. With respect to subsection 2, furnish a copy to the person on request with respect to because it's an hybrid prospectus, right? So probably have to go with. And if you are not following the provisions, then the company is liable for 50,000 rupees per default. Please highlight. See, this is following for subsection 2, right? Subsection 2 says you have to furnish a copy to the person on request. If anybody is asking for the details, you have to give the person all the details. If you're not dealing, means it's a default. For one default, you have to pay 50,000 rupees penalty. Is it okay? Yes, pa. So section 33 is for the general provisions. Now, remaining section 34 to other sections and all will go for liability. Shall I take over? Criminal liability from the statements. What do you mean by misstatements? Please highlight them. Very, very important. Untrue statement, misleading like, or sometimes included or omitted. But because of this inclusion or omission, it's misleading a judgment. You cannot, probably because of this line, you are planning to go for buying the shares of the company. So this is what you call as misleading. Person who authorized shall be liable under section 447. This is a liability section. Criminal liability is section 447. For whom it is non-applicable. Probably owners of burden will be given. I heard of this one, owners of burden, which means burden of proving. Okay, I might have discussed, I don't know. Burden of proving. Okay, burden of proving. Okay. What is this burden of proving means? Who is liable to pay the penalty? The person who is authorized for this. Probably they pass a resolution and a person will be authorized for holding all the prospectus details, vetting and everything will be done. So that respective person will be now liable for this 447. But if he proves that statement or omission is immaterial. See, it's the line we added, but because of this line, the judgment is not going to be wrong or right one. So it's not material. See, materialistic only will be considered. And this is a reasonable ground of belief. Probably at that time, till the time of issue, the statement was true or included, or this one is necessary. But now it seems to be not necessary. So that's not our fault, right? So if it's clearly that person who's authorized is clearly proving means, then this penalty is not applicable. Which means what? Section 447 is not applicable. Okay. Section 35, civil liability from the statements where a person has subscribed for the securities, has sustained any loss or damage because of what? Because of this inclusion or omission. Then company and every person, who's that every person? Director, or who's the person authorized in the prospectus, authorize his name to give in the prospectus, or please highlight. He's not a director now, but he has agreed to become a director either immediately or after a period of time, interval of time. Promoter, person authorized to issue the prospectus, probably a KMP like a CEO or other persons like, an expert also. See, we are following from section 5, subsection 5 of 26. We are talking about the expert statements. All these persons will be liable for punishment under section 36. 35 says it's a civil liability. Penalty is there in section 36. What is the penalty? It's a civil liability, it's a compensation penalty. Okay. Subsection 2, for whom it is not applicable for. Yes, director, the consent is withdrawn before the issue of the prospectus and issued without his authorities or consent or without his knowledge it is being issued or becoming aware. Please highlight this one. See here. He says that I have given the statement, but I came to know this is not the right statement. I asked them to withdraw the statement. They have not withdrawn. If I'm able to prove that, as an expert, if I'm able to prove that, yes, I can do it. So sometimes like expert misleading statement may be there, or copy of extract from a report or valuation of an export may be there. Probably in future you may be as a chartered accountant. Most probably this goes for chartered accountant only. You will be valuing the shares, and you have to give a valuation certificate. This shares is, see, you go and sell in the market. The share value, that is the face value of the share, is just 10 rupees. Okay, you go outside the market, you sell with the premium for totally 450 rupees. How can I believe that this is 450 rupees, 54 rupees shares? And this is CA expert statement added. The CA has valued your shares and he has added that this is worth 454. Yes, then it's accepted. You are not going to question. The government will not question because the auditor has certified this. The auditor has valued this. Okay. So in this case, if it is 454, he's an expert in this case, right? So we say this as expert statement only. Okay, so this may be valuation of an expert or whatever it is. And there is a reasonable ground to believe that the person is competent. Whom do you call as competent person? Sound-minded. No lunatic, no drunkard. Okay, sound-minded. And are not withdrawn. Please highlight. The person is competent. He has given the valuation of all the other things of the expert statement. We have included. And not only that, he has not withdrawn the consent before filing the prospectus, then defendant knowledge before the allotment, then probably he may also be right. Okay, he has to check. At the same time, if it is done by mistake or misstatement is fine, but if it is done with an intention to defraud, which means what? Particularly to fraud, then it is a completely okay. So unlimited liability. What do you mean by unlimited liability? Totally wrong. Okay. Section 36. Let me finish off this content. Okay. Punishment for fraudulently inducing person to invest money. What do you mean by inducing? Tempting you to buy money. So the company shares, they are doing well. So you buy shares in this company. I'm just tempting you. Okay, listening to my words, you say, okay, ma'am is saying I'll buy it. Because you get tempted. I see my intention is not to wisely make your investment, but my intention is to invest fraudly. Fraudulent should not be done anywhere. Not only in companies act, in personal life also, right? So knowingly, see the term is starts like this, knowingly or recklessly makes any statement. See the font's title is default. Okay. So probably statement, promise, you have a different concept, so don't worry. Any statement, promise or forecast which is false or deceptive, which means what? Attracting you or misleading. Not only that, it is not giving the full details, concealing material fact. Only intention why they are doing this to induce another person to enter into this contract or offer to enter means the agreement to acquire, dispose, subscribe or underwrite securities or the agreement for which the purpose you are doing this to secure a profit. Okay, because of the fluctuation in the market. Okay, or the agreement to obtain credit facilities from any bank or financial institutions. The liability will be which liability? 447. We have to link 34, 35, and 36. We have to see all the three together. What is 34? Please join with me. Criminal liability. What is 35? Civil liability. 35 subsection 3. What it says? Unlimited liability in case your intention is to defraud. Then go for section 34. Now section 36. What it says? Section 36. You are fraudulently inducing. Then go for 447, which is section 32. Okay, fine. Actually, section 34 is also saying go for section 447. Okay, so everything are redirected to 447. That's about criminal liability. Okay, section 37. Action by affected persons. Yes, what you can do? It's a breach of contract, right? You're not promising as per done. You're not performing as per done. Then you can file a suit or take such other action. What such other actions? They'll go for litigation like class action suits. You remember the very first page of Companies Act we have this. This is the highlight of 2013 Companies Act. They can go for class action suit or they need not go directly to the tribunal, National Company Law Tribunal. What they can do is they go for filing a class action suit. They can go for issuing a common memo like to the company. They can proceed in this order. Okay. Who is the affected person? Any affected person by the misleading statement, probably covered under section 44, 34, 35 or 36. Who can find any person or group of persons or association of persons because of this. Section 38, punishment for personation of accusation. I'm using your name. Okay. Or I'm trying to use your name, which means I'm not actually investing in mining. That's what you say. Okay. I'm not actually investing in mining. So subsection 1, any person who makes or abates. What do you mean by abates? Tundrathu. Okay. You are not directly making it, you are making others to invest in that. So making or abating to make in a fictitious name to a company for what? Acquiring, subscribing to securities, or makes or abates making of multiple application. Multiple application should not be done. You can go for subscribing, offering the shares in only one application. We should not do it multiple application. So first one is fictitious name. Fictitious name is what? No name at all. There is a company, A company. It is incorporating another company, B company, which means what? This is a holding company, then this is a subsidiary company. The only intention for this B company is to buy shares in another company. Because what law says is you should not raise the capital and invest in another company. You have seen, right? You should not raise the capital and invest in another company. In case A company is directly investing in another company, this is not allowed. It's against law. So A company is incorporating B company, and B company's object clause says it is only purpose incorporated is to buy shares. Means obviously it's what doing defrauding. It's creating a name which is not available. It's fictitious. So second point is making multiple application in different names. See, you can make in different application, but not in different names. Or like combination, you should not do that. Okay. So of his name or surname, so you should not do that. Or otherwise induces directly or not to allot, register or any transfer like okay in fictitious name. So what is the liability for? Oversight. Okay. That's what jail now. Subsection 2, prominently reproduced in every prospectus and application form of security. So, what are the things you have to clearly mention? Mention even this one also. Okay. Subsection 3, with respect to disgorgement order. What do you mean by disgorgement order? Means profit or gain something which you have gained genuinely. Okay. If you have done some misleading thing and because of this you have achieved any gain means, you have got any gain means, you have to reverse this. This is what is called as the disgorgement, and this order will be passed by the court. The court may order disgorgement of gains and cession and disposal of securities in possession. And that amount will be credited to IEPF, Investor Awareness Fund. Okay. Investor Awareness and Education Protection Fund. Okay. Yes, I've just listed all the penal provisions because you may expect this as what are the penalty provisions covered under prospectus. So you have to list everything. Can you please have a look here? We'll go for allotment of securities. The provisions applicable here are Part 1, 39 to 41, covering from Chapter 3. What do you mean by allotment? Beautiful definition. Actually, when we go for this capital, it's called as unappropriated capital. Only when it's allotted, it's called as appropriated, which means what? Given. When we say it's 10 lakh worth share capital, how much? 1 lakh shares of 10 rupees each. This figure is there, but it is being given to the investor, the shareholder, no. Am I right? It's there as a figure. See, the authorized capital need not be same as subscribed capital, need not be same as the issued capital. This 10 lakh is just a figure in the paper. This is unappropriated capital. When it goes for subscribed capital, probably they are planning for 8 lakhs. And 8 lakhs is completely subscribed and completely issued. Then this becomes appropriated. So allotment is nothing but appropriating the unappropriated capital. And only when we talk about allotment, share comes into existence. Please try to recall the Contract Act. Offer is there, and one person, the offer is accepting the offer. We call the contract comes to existence. The same way here, prospectus is there, prospectus or subscription, or whether we go for a memorandum of association or whatever it is. The offer is nothing but applying. Okay, after applying, the company allots the share. Only after allotment, the contract comes into existence, which means here the share comes into existence. Before that, we don't have any concepts called a share. Okay. So allotment of securities by company follows in section 39. Subsection 1 says allotment can be made when you only receive the minimum amount, and that minimum amount has to be stated in the prospectus part. And the sums payable on application for the allotment so stated have to be paid to and received by the company by check or other instrument, not by cash. Okay. Subsection 2, application money should not be less than 5% of the nominal amount, which means face value of the capital. 5%. See, you might be issuing the share for 450 rupees. That doesn't matter. What's the face value of the share? 10 rupees. Okay, 5% of 10 rupees. 50 paise. At least this should be the application amount money. See, it can be more than that also. What the act says is at least 50%. First percentage specified by SIB. Okay. Subsection 3. If the state aid is not received within the period of 30 days from the date of issue of prospectus, then the amount received shall be refunded. That is returned. Refunded means returned. Okay. So within how many days you have to receive this amount? Within 30 days. Okay. Else the amount shall be returned at such time as man is specified. And if you are going for allotment means you have to say that we have filed a return of allotment and there is a particular format for this called as PAS 3 applicable for a company having a share capital only. If a company is there having no share capital only, this is not applicable because we don't have something called as share capital. And if the company and if there is a default with respect to the above provision, the company and its officer is default, whichever is lower of 10,000 rupees per day or per default, per day, per default, or 1 lakh rupees. Okay, so this is the penalty provision. Shall I go for 40? Is it okay? Securities to be dealt in stock exchange. Subsection 1 of 40. It's applied to the recognized stock exchange. See, usually in most of the cases we use R-SC. It's understood format. Okay. Being a professional, we usually understand. It's mentioned as R-SC. SE means stock exchange. Okay. NSE, BSC. Okay. If it is mentioned as R-SC means recognized stock exchange. It's understood. Okay. So you have to get the have to obtain the provision from the securities which you are dealing with stock exchange. See, they are mentioning as securities. They are not mentioning as shares. Probably you might be a company where you are listing only the debentures, not the shares of a company. You might be having a very little share, but you might be having a big amount of debentures. To do the secondary market trading, you need to list the debentures also. So probably you'll not go for listing the shares. So usually they call it as listing the securities. Securities having a wider meaning. Okay. And the names of the stock exchanges has to be stated in the prospectus. All the application money to be kept in the escrow account. Okay, so this is all normal. Probably when you go for allotment of securities, you can adjust this amount and you can apply, you can take it for utilization. Okay, so this is all normal only. For the repayment of monies within the time specified. So it's mentioned, right? If you are not utilizing, then you have to repay for unallotted securities. Okay. Yes, go for subsection 4. Any condition permitting to require or bind any applicant for securities to waive compliance. Probably have to follow all these provisions. If it's a listed company, definitely you're going to follow SEBI also. If you're not following this, or you're mentioning anywhere the condition saying that you're waiving this compliance means as an investor, you're waiving now. You say that uh, ஓகே எனக்கு தேவையில்ல அந்த செக்யூரிட்டி வேணும் நீங்க யாருக்காவது பேர்ல ட்ரான்ஸ்ஃபர் பண்ணிக்கோங்க அப்படின்னு சொன்னா அதுக்கு பேர் வேவிங்னு சொல்லுவாங்க விட்டு கொடுத்ததுன்னு சொல்லுவாங்க see it's your right how you can leave the right you don't have the right to give your right okay for example uh, you will receive next month's salary okay how much salary you receive 50,000 rupees you are going to receive next month you want to donate it to the PM fund flood natural calamity and fund. You say that next month I'll receive the salary, I'll donate it to you. You don't have the right because you have not received the salary yet. Once you have received the salary, you can do it. See, you're saying or you're giving a promise saying that I will donate it once I receive it. No, you cannot do that. See, it's your right to receive the salary. See, I'm not talking about donation. I'm talking about the right to receive it. Who has the right to receive the salary? The employee has the right. How can you say the company that you can directly transfer to? Again, you can ask me, ma'am, there are some provisions where you get the house loan and directly. See, that's a contract. Because of the salary and other things, only your loan is being given. The loan has been attached over it. But donation is not a contract, right? The donation is, I'm talking in the sense that it's your wish you can donate it or not. Next, see, today I'm having this intention to donate it. Tomorrow I'm getting married. Day after tomorrow I'm getting child. Okay. So what happens automatically? You will be worried whether to donate or not. Mind changes. And when you go for housing loan, you have to pay for the remaining 40 years of period to close the housing loan. How are you going to do it? Your salary is there. It's attached. And also, if you keenly check on that, Only when the salary is credited, it will be transferred to the account. Only when you, which means what? That 1 month work is done. After that, the salary is being credited to your account. But instead of crediting directly, it goes to them. That is done only. But you cannot, this is what you call as waiving. Waiving means your right. You take the right, you execute it. Nobody has the right to execute your right. So if it's done in this way, it's not valid, it's void. It's a beautiful provision. Not only here, you will refer this in many acts. Okay? And subsection 5, yes, not following default. Penalty for company 5 lakh to 50 lakhs. Officer in default 50,000 to 3 lakhs. And yes, you can pay for commission also. So that's a normal point. And we know that GDRs, right? I have already discussed. If you are going for issuing shares to the outsider, that is outside foreign country, then you have to pass special resolution in prescribed manner. You have to follow the depository receipts and all regarding provisions. Miscellaneous, what are the things you have to there? You have to give the details in PS3, list of allottees, name, address, occupation, number of securities allotted, other relevant information, your copy of contract. It should be a stamped document. Okay, it should be a stamped document. With respect to property, assets, other securities, it may be fully paid or partly paid, but for bonus shares, it should be fully paid. So it's a normal concept, right? If there's no copy of contract, there should be a particulars and valuation report. Who will give the valuation report? CA will give the valuation report. For bonus issue, uh, general meeting will be held, right? Only in the general meeting can go for issuing bonus shares. So this bonus general meeting resolution has to be passed. Okay. Proper authority to allot securities. Yes, board of directors, a committee may be separately allotted for this. If not qualified, but known later, probably we may not be knowing who is the particular committee. Probably may do it later. It's similar to acceptance under Indian Contract Act. Reasonable law will follow. It should be absolute and unconditional because acceptance should be absolute and unconditional. It should be properly communicated. Against application only you can do it. Without offer, you cannot go for acceptance. Probably along with this, you can write a note. Okay. Refer Indian Contract Act 1872. Legal rules to acceptance. Legal rules to acceptance. If you have the Indian contract material for CMA, you can find it directly. Legal rules to acceptance. It's there in second heading. If you're a CA student, then you just go for single material. Download single material and see this one. All these are there. It should be done against application money only, which means there should be an offer, then only not in contravention. You cannot allow to a minor. Minor is not capable. But minor through a guardian for fully paid up shares is capable. Okay. So just refer all the Indian Contract Act provisions for. Irregular allotment is often repeated. If you're not applying the following, like you're not giving the prospectus as per the provisions, self prospectus will follow these provisions. Definitely follow these provisions. So you have to follow those provisions and you have to give a copy to the registrar. It should not be anything related to fraud or fraudulent issue or as per listed by SEBI. Minimum subscription amount should be there, minimum subscription of shares should be there, and you have to give the CAS3 and separate account, escrow account should be there. So you'll be creating this account. Probably your company name is ABC Limited. Okay, so you'll be creating an account called as ABC Limited Share Application Account. Share application account. So this is how you pass the entry, right? Share application account. Okay. So actually, before that, you have this thing. And once you get the allotment money, another account will be created called this as ABC Limited Share Allotment Account. Okay. And this amount will be transferred from here to here. So this is what is happening. Okay. Once it is allotted, means you'll be just transferring this to the share capital in the balance sheet. Refund of money, yes, minimum amount in case has not been subscribed means application money not received within 30 days. Which not subscribed means then you have to repay within 15 days. Else directors will be please highlight jointly and severally liable. What do you mean by jointly and severally liable means we cannot say because of one director, other directors lose it. No, everybody has done it. We cannot say it's only the one person's role or default. Okay. So that's about part one over. We have to go for part two. Okay, can you please go through till here? Private placement, other than the issue of prospectus, which means instead of issuing prospectus to the public and see, we already noted with earlier provisions. This is the day you are giving the prospectus or copy to the registrar. Okay. Within 3 months, so not 3 months, 90 days. Within 90 days, what you have to do? we have to give to the public. This itself is maximum 3 months. Okay. Before that, you might have given to the SEBI. So mostly listed company, right? Before that, you have worked for this. So that means it's going to take some 5 months or 6 months or more than that. But I'm in need of urgent of money. So what I do? I go for private placement. That is, instead of going for this lengthy procedure, we go for shortcut. But if it is a shortcut, we have to check if it's legal, right? And law gives us provision, section 42 completely says it's legal. But you cannot bring a full public inside, maximum 50. Okay. So you also call this as preferential basis. Why it's called as preferential basis? Because company will prefer the people. Okay, I just tell to Kavita, I'm going to issue the shares. I'm in need of money, so you buy the shares. Kavita says, ma'am, I know Anita, ma'am. So Anita will buy, ma'am, because she's interested in the company. Okay, tell Anita also. Like word of mouth. Actually, this will happen in private company. That's a closely held company, really the known persons will come inside. Here also happens the same thing. Because today you will say you will give 1 crore. Tomorrow, I cannot come behind you, right? So that's happening here. So preferential basis or see, please focus on the alternate names. That's important for us. Preferential basis or private placement other than the issue of prospectus. So private placement, any offer or invitation to subscribe or issue of securities to a select group of persons, please highlight, other than by way of public offer through private placement offer come application which satisfies the conditions specified in this section. Okay, applicable provision, part 2, section 42, only one section, section 42, chapter 3. Applicability subject to provisions, they clearly say that subsection 1 clearly says that if follow all the remaining subsections of the section, then this is applicable. If any one section is missing, then it's not applicable. Okay, it's very clear in the statement. So what subsection 2 says is you go for selection of group of persons, identified persons, please highlight. Whenever you go for filing a statement with the registrar, you have to give the names and occupation and address and all. Okay. Identified person, who will identify? Usually the board of directors, maximum 100 or as may be prescribed. But when you go for this case, you need not include the QIBs. Whom do you call as QIBs? Means qualified institutional buyers. Qualified institutional buyers. Actually, there are big companies, their sole intention of formation is just to invest on. So you can give for those companies. Okay, or employees under ESOP. They both are not covered for. So 50% found means QIBs and ESOP employees are not covered. Okay. With respect to subsection 3, you can issue this offer and application. You have to record the names and registers and not to carry the right to renounce. Please highlight. This is not a right share, right? Only the right share will carry the right to renounce. This is a share. Obviously, you are giving the right, but not the right shares. Okay, you should not get confused with right shares and this one. So they are clearly stating that you should not carry the right to renounce. But it happens the right share means definitely they will be given because law says while giving the right share, you have to give the right to renounce also. So need not get confused with the section. This subsection 3 clearly says the names and the other persons will be identified here and it should clearly mention that not to carry the right to renounce. Explanation you can just go through. Important part. If there are more than 50% means, and obviously it becomes a deemed public offer, follow all the part 1 provisions. Subsection 4, identified persons, they can apply through application along with subscription money. See, this will look as if the company has given a prospectus, the identified persons are applying through a application, but actually it's not working like invitation to an offer. You cannot exactly match with that concept here because it's not actually going to work in that manner. Okay. So through check or DD or otherwise, not by cash, and utilize money. Please highlight you can utilize this money only after allotment and it is filed under subsection 8. Subsection 5, another fresh offer. Yes, you can do it, but only after completion of this, or in case you are withdrawing, or in case you are abandoning. Yes, you can do it, but only after this only you can go for fresh offer. Shall make more than one issue subject to the maximum of identified person. Probably for 1 year you are planning for this. Okay, maximum 50% only. First issue I'm going for 10%, fine. Second issue I'm going for 20%, fine. But maximum all put together should be 50%, right? Subsection 6, allotment of securities within how many days? Over there, within 30 days. Over here, within 60 days. Okay, please be very careful. CMA inter, this is all data specific questions. Okay, if not refunded, then If not allotted, then you go for refund within 15 days from the expiry of the 60 days. Within 60 days, then plus one 15 days. Okay. If not repaid, then repay with 12% interest. See, this is the day applied. You take 60 days for calculation. This is the day within which you have to go for allotment. If not allotted, from this day, 15 days, you go for repaying. Or not actually, I should not use the term repaying, sorry. Returning. Returning is different and repaying is different, okay? So I should not use this one. So this is not repaying. It's not writing, sorry. Okay, let me use this board. So this is the timeline. So this is the date when they go for issuing this prospectus or whatever the case is. Within 60 days, they have to allot it. Okay, so this is the date. After the 60 days only, you have to calculate for 15 days. Okay, which means you have to go for returning the money. Okay, if you are not returning within this 50 days, return means they have paid 20 rupees, you return 20 rupees. If you are not returning within this 15 days, then after each day you have to pay along with rate of interest. So here you are repaying with rate of interest after this extra days. One thing you have to take a note. Second thing, please highlight this 15 days is calculated after 60 days only. Probably for X, Mr. X, you are allotting in this day. For Y, you are allotting in this day. For Z, you are allotting in this day. Need not worry. It's meant for 60 days. After 60 days only, you'll calculate this 15 days. See, these two provisions are important. First thing, this percentage of interest after the 75 days only. Am I right? 60 plus 15. If not allotted means something, right? And this separate allotment is done for separate person means it's taking different dates and no. This 15 days is calculated after the 60 days only. Is it okay? Hope I'm not confusing. So if you're saying that you're allotted for Mr. X and you did not allot for Z, you need not calculate from this period. You'll calculate from 60 days only you'll calculate. Okay. So other provisions are similar. So you go for bank accounts. So 1 second, let me read on the page. Other provisions are somewhat similar provisions only. You should not utilize for other than this purpose. Why did you collect that money? As a share application money, then you have to use it for allotment of securities only. Okay. And repayment in the case of disability of allotment. This is often asked question. Okay. Then with respect to subsection 7, no public advertisement, please highlight. Because if you give a public advertisement, it becomes a prospectus, normal prospectus, public offer. So you cannot utilize any media, marketing, distribution channels or agents to inform the public at that. Only thing what I can do, I can tell to Anita. I can tell to Kavita. Okay, nobody else. Okay. Subsection 8, you have to file a return of allotment within 15 days of allotment with relevant information. Okay, names and other address and all. Okay. Then with respect to subsection 9, it's a contravention provision. If you're not filing this rate of return, then company promoters, directors, they will be penalized for 1,000 rupees per day. Maximum it can go for 25 lakhs. With respect to actually there are two penal provisions. One is with respect to contravening subsection 8. What is subsection 8? Not filing the return. And this is subsection 11. Contravention subject to subsection 11. What is subsection 11? Deemed to be public purpose, which means what? It crosses above 50%. In that case, if you follow the subsection 10, it is applicable for company promoters and directors. There will be a fine levied, whichever is lesser of amount raised through private placement or 2 crore rupees. Okay. And also we have to refund by the company this interest within 30 days of the order of imposing penalty. Okay. Actually, when you go for this 42 itself, you are getting 3 penal provisions. And one is interlinked with other. See, if you go for subsection 9, it is interlinked with subsection 8. If you go for subsection 10, it is interlinked with subsection 11. Subsection 11 says that it is called as deemed public offer because you are not following as per the provisions. Okay. So you can just follow this one. Miscellaneous can manage cash or other than cash. Yes, so you might have received the amount not stated as application money or allotment money put together consideration other than cash. So cash or other than cash, but you have to pass a special resolution and that price has to be stated. You should be included in articles of association. You pass special resolution along with the explanatory statement. You should be fully paid at allotment itself and allot within 1 year of passing of, yes, please highlight one. Allot within 1 year of passing of special resolution. If that 1 year is over means you have to go for passing new special resolution to get the new validity. Okay. Else less than 50% of the earlier financial. That's about this heading.